So I
Okay.
want, sir, we received one mail that paper is not required, but actually I'm confused regarding that issue.
No, haven't you received email that the requirement
Sir,
of the term paper has been waived? Haven't you received any email from the department in this connection?
yes, sir, yes, sir, yes, sir. They have waived the requirement of term paper.
Yes. Then what is the confusion?
That on 5th June we have to submit, but on the evening we received the mail from FLS, the waiver of the term
Oh,
paper. So I got confused.
everything, brother, try to apply your legal mind. You are a law student. Try to apply your legal mind. The
Yes, sir,
last
yes.
notification is the prevailing notification. The last notification that has been issued by the competent authority of the department shall prevail. And whatever the previous notifications, emails, whatever you have received, they become infructuous. They do not entail any kind of a consequence. So there is no confusion at all.
Okay, sir. Thank you, sir. Thank you, sir.
Yeah,
Thank you, sir.
you're welcome. Let us get down to business now. I welcome you all. I welcome Ms. Prakriti, Jamshed Bhai, Mr. Sultan Mahmood. Let us get down to business now. We were deliberating Syrian refugee crisis, Rohingya refugee crisis, and the legal implications which we have been witnessing in this connection. I was talking of that there are certain important legal issues which we have tried to identify yesterday, and how to respond to these issues, that is another important dimension. But before I proceed further, it is equally important to what should be done in this connection. An estimated more than 10 million Syrian refugees have fled their homes since the outbreak of the civil war in the month of March in 2011. Affected countries, my dear friends, if you take into account the subsequent circumstances after the Syrian refugee crisis, then the affected countries are divided on how best to resettle these asylum seekers. There have been certain important developments on many occasions. Earlier, I have alluded, I have deliberated and made references those important developments, and particularly one of the most important treaty becomes relevant in this context, and that is the EU-Turkey Treaty of 2016. And under that very treaty, some roadmap has been envisioned. But we should not forget, when there is a question of accommodation of the Syrian refugees, then basically we have been talking of the institution of asylum. Asylum is considered to be the basis for giving refugees protection, but there are scholars that asylum does not work if there is in the absence of any kind of a political will. Under all circumstances, there is a requirement of the political will, and it is basically the political will of all the geopolitical entities, whether they are the neighboring countries, whether they are the remote countries, It is basically the political understanding and political premise upon which the entire institution of asylum functions. There is evidence, my dear friends, to show that most Gulf states in this particular region or surrounding Syria have passed various measures that aim to facilitate the entry and stay of Syrians since the outbreak of civil war. And only about 10% of the asylum seekers have fled to Europe, if you take into account the entire Syrian refugee population. There are certain important depictions. Particularly the popular media has readily criticized the international community as a whole for their failure to provide refugees with shelter and an adequate standard of living. In such a scenario, there are certain important fundamental policy recommendations, and these policy recommendations in the light of these deliberations, whatever the deliberations I have submitted yesterday, I try to encapsulate what should be the potential solutions. However, no solution is going to have any kind of a finality when we are addressing refugee crisis on this beautiful planet. Because there has been so much transient criticism of the systems which have been designated, designed, and envisioned for the protection or for providing protection to refugees. This is my well-considered opinion, my dear friends, despite the fact since the inception of Treaty of Westphalia in 1648, international community has been trying to emplace a system to address the problems of refugees, but unfortunately, Committee of Nations has not been successful completely. Because the international community is simply not well equipped to facilitate a surge of people seeking asylum. I don't know whether it is going to be addressed as a failure of international law or not, or it is going to be addressed as a failure of international community, because international community could be held responsible for the non-implementation of international fundamental principles, and nation states have not been sincere enough in discharging their international obligations, particularly in the area of international human rights norms. Therefore, it becomes necessary to question the political commitments, moral convictions, and the international leadership who has been espousing the cause of human rights and democracy, rule of law, constitutional exceptionalisms of various manifestations at international level. Because major countries of the world have been willing to carve out a role for themselves as an international leader. But the political commitments have not been translated into action, despite the fact community of nation states under the auspices of the United Nations organization have come out with various instruments for accommodating and providing protection to refugees. And basically we have been talking, though the commitment is political, but we have been talking protection in the legal terms. Or in other words, let me put it like this, we have been talking of legal protection to refugees. But this idea of legal protection has got a very narrow focus. Because 1951 UN Convention relating to the status of refugees, that is today considered to be a Magna Carta of refugee rights. It is considered to be a treaty of peace for refugees. It has got some kind of a divine status. When people like me have been attributing the highest regard to this international instrument, particularly in the post additional protocol enactment in 1967. This is an instrument, and some of the provisions of this instrument, as it is axiomatic from our deliberations since week first, that some of the important provisions have been recognized by majority of the scholarships in the area of international refugee law, that it has attained the status of preemptive norms of international law. It has become the part of customary international law. Because the non-refoulement has always been the part of, historically speaking, traditionally speaking, it has been the part of each and every geopolitical entity on this planet. Therefore, my dear friends, the 1951 Convention applies once a state can identify the status of the parties. But these kinds of pleas have always been taken by the recalcitrant nation states. As I have mentioned yesterday, that there have been certain important arguments, even in India, even in Pakistan, including Bangladesh and rest of the jurisdictions beyond South Asia, particularly by those countries who are not the party to 1951 Refugee Convention or 1951 Geneva Convention. They are supplying this argument just to absolve themselves from any kind of an international responsibility, or just to not to own any kind of international responsibility or responsibility sharing, as it has been envisioned in the Global Compacts in 2018. It means that the states are only bound by the convention once an asylum seeker has been identified as a refugee, as per the mandate of 1951 Refugee Convention. don't see this particular, argument as a palatable, tangible argument. In my estimation, this kind of an argument, my dear friends, is a preposterous argument. This is an argument which basically derails the entire idea of customary international law norms on refugee protection. Because as a student of international refugee law, I am of the view that the refugee crisis is not a crisis of a particular nation state. Human migration, human displacement, human relocation, or humanity when crosses international borders, that becomes the collective problem of the entire humanity available on this planet. Human sufferings and pains cannot be divided on the basis of what we call of citizenships and nationalism, geopolitical entities. This cannot be the criteria. Same is the case, and with the same lens, with the same prisms, we should try to address the problems of Mexican refugees, Venezuelan refugees, Rohingya refugees, Syrian refugees, and the minorities who are still on the move in many parts of Europe. When we are talking of law to accommodate refugees, basically we are talking of stability, continuity, and dignity. Because legislation is considered to be, and this is something I am saying again, I have been saying it time and again, that legislation is considered to be the most effective instrument to stabilize human existence. And that is why we require a law to address, to accommodate, to respond to the refugee crisis. Syrian refugee crisis has basically testing the boundaries of international law. And it is up to the international law scholarship to determine the province of international refugee law by exploring the boundaries of international refugee law. Because Syrian refugee crisis and the Rohingya refugee crisis, my dear friends, are crises of colossal magnitude, immense enormity, and created very, very adverse implications for international law. Therefore, it is the responsibility, a collective responsibility, as it has been envisioned in the global non-binding, what we call, or rather I should say the soft law that has been adopted in 2018 in the month of December, under the auspices of the United Nations, which is popularly known as the UN Global Compact on Refugees and Migrants. No policy prescription, no descriptive delineation, no what you call, administrative argument going to be sufficient to address refugee crisis in a given situation. Because on daily basis, we have been witnessing the new arguments, new grounds, new reasons for human displacement. And that is why we are having a Eurocentric definition of refugee. We are also having Africa-centric, definition of refugee. We are also having South America-centric, what you call refugee definition. And in addition to, rather, I should say, the national definitions emanating from different jurisdictions at international level. Therefore, when we are addressing these two important crises, Syrian refugee crisis as well as Rohingya refugee crisis, then we should not forget, my dear friends, that in 1951 Refugee Convention, states agreed to provide refugees with a wide range of basic rights. Because there are certain important specific articles of 1951 Convention which I must bring to your kind perusal and notice. Particularly Article 27. When we are talking of protection of refugees, rights of refugees, range of rights of refugees, if again I seek your affirmation to incorporate Hannah Arendt's orientations of the refugee rights, and the most fundamental right which she has been talking and taught is basically a right to have rights. When we are talking of rights of refugees, it does not mean we have been talking of only the substantive right, and one of the most important substantive rights that must be made available to refugees is basically right to life. I understand that the right to life is the non-derogable right, non-negotiable right, most substantive right, a normative right. But we have to transcend this right and go up to what we call Article 27, which takes into account a very, very important right, which is generally denied by the nation states to refugees, and that is basically a right which takes into account administrative assistance. Right to have, we have been what we call, talking of constitutional rights, right to constitutional, remedies. All the South Asian constitutions have been, talking this particular right, and the constitutional remedies are available to the citizens of all the geopolitical entities in South Asia in case of violations of their, fundamental rights or in violations of their fundamental freedoms. So this kind of a right has also been incorporated with a different kind of a flavor, or with a different idea of, semantics. And it has been incorporated as Article 27, which takes into account a right to have administrative assistance. There is another important, understanding when we are talking of this particular right, that is administrative assistance, the grant of permission to transfer assets. That is another important right. I mean, in Syrian refugee crisis as well as in Rohingya refugee crisis, in a limited sense in case of Rohingya refugee crisis, but in a later sense in case of Syrian refugee crisis. Because the Syrian refugees, and majority of them are of the view that they don't want to return to their country of origin. So in such a situation, Article 30 and Article 27 of 1951 Geneva Convention on Refugees become very, very important for them. Because Article 30 takes into account, my dear friends, the idea of granting permission with regard to the transferring of assets of refugees. So there are, refugees from, Syria who have been, contending that their assets, their properties in the country of origin must be transferred from that very country to their country of destination or country of resettlement or country of reception. That has created, because here the role of the governments, because my friend Mr. Imran has been working on one of the aspects, and that particular aspect is right to compensation. So right to compensation becomes very, very important, or right to reparation. Because when we are talking of solutions of refugee problems beyond durable solutions, because we are having a trinity of solutions, and this trinity of solutions have also created a trichotomy. And just to what you call, subside, just to decimate any kind of a dichotomy or trichotomy, we require soft law in the form of global compacts, and the global compacts have also been what you call, talking beyond durable solutions. And these durable solutions, beyond what you call, their brief, we have been talking of the element of complementarity and common pathways. But it has become a fashion, my dear friends, and I see it as a fashion, that majority of almost more than 180 nation states have immediately and readily agreed to accede to global compacts. And the frameworks and institutional, frameworks which have been envisioned in the Global Compact on Refugees have already started functioning in the major regions of the world, particularly in Africa continent. Why I am calling it a fashion? Had it been a legally binding instrument, they would not have, agreed. They agreed only because it is a non-binding instrument. That is why majority of the nation states are of the view, and they are in quest to attain some kind of a moral high ground. And just to endorse, just to submit their endorsements, they are very sincere so far the refugee problem is concerned. And they have been, functioning in the political palliation of the refugee problem. And they have been undertaking all the measures because the review program that has been envisioned in the Global Compact on Refugees is similar to what we call the Universal Periodic Review, what we have deliberated in the previous semester in the classes of international human rights law, where the nation states do not own any kind of responsibility. In this follow-up review, as per the Global Compact on Refugee, does not entail any adverse consequence for the nation states in case of any kind of non-performance or not sharing international responsibility for the refugees. Because the normative understanding is already there. There happens to be a legally binding instrument in the form of 1951 Convention. But the idea of the Global Compact has primarily highlighted the political implications of the refugee crisis. For me, as a student of international refugee law, that is the only point of solace. Moreover, my dear friends, 1951 Convention proposes as a minimum standard that refugees should receive at least the treatment which is generally accorded to the non-citizens generally. But of late, as I have submitted yesterday, in the wake of restrictive measures and the emergence of the ultra right-wing nationalism in the majority of the nation states, these minimum standards which are generally accorded to the non-citizens have taken the back seat, and the refugees have become or perceived by the non-state actors in these territories, in these geopolitical entities where the right-wing nationalism is emerging, whether it is Spain, Austria, Germany, and many other European nation states, including what we call in global South nation states. The refugees are being perceived as a threat to the national security, as a liability on the national resources, as an ambassadors of terrorism, as an elements or agents of radicalization. Lot of attributions and imputations, adverse imputations are being leveled against them. This reminds me of a very, very important instrument, and that is the 2004 Qualification Directive of the Council of Europe, which basically defines the EU states' notion of refugee, where the idea of subsidiary protection under this particular directive, idea of subsidiary protection has been contemplated, particularly for those refugees who have been confronted with the real risk, a real risk of serious harm if they are sent back to their country of origin or countries of origin. And this clearly applies, my dear friends, to a large number or to a large majority of those coming from Syria and the surrounding regions. Dear friends, The cornerstone of 1951 convention is arguably the principle of non-refoulement, as I have already submitted. Because nation states must understand, my dear friends, that all persons should enjoy the right not to be deported, not to be returned to a country where they may be subjected to persecution. And it has been established, my dear friends, beyond any kind of doubt, that basically this is a principle of customary international law. It should apply to all countries, regardless of whether they are a party to 1951 Geneva Convention on Refugees or not. As such, it is quite clear that the 1951 Geneva Convention on Refugees has codified some parts of customary international law. And this should not be forgotten, especially those relating to the basic rights of such refugees under articles, which starts from Article 14 and goes up to Article 30, as I have submitted, particularly Article 27 and Article 30. Because, in my understanding, these 15 and 16 articles of 1951 Convention, Refugee Convention, must be considered as a part of customary international law. And a breach of customary international law, my dear friends, attributable to the state in question will invoke state responsibility for the internationally wrongful act under Article 1 of 2011 International Law Commission, Articles on Responsibility of States for Internationally Wrongful Acts. Therefore, the state will be required to make full reparation for the breach under Article 31. And if, my dear friends, if the obligation is owed to the international community as a whole, for example, we can give an example of the erga omnes obligation. Under Article 48, subclause 1b, any state shall be able to invoke the responsibility. Given that, my dear friends, international refugee law overlaps with human rights law, and that the basic principle of non-refoulement and of temporary refugee are customary in nature, it is highly likely that the such obligations will be erga omnes. Obligations, application of such what we call obligations varies. Since it depends. It depends, as I have been submitting, it depends on the political will. And political will of the nation states to take positive steps, positive what we call measures to enforce these kinds of what we call norms. Although, my dear friends, it is particularly effective in isolated situations, it has yet to apply in a meaningful manner if the large number of states are potentially found to have been committed breaches, as is the case in the current context of Syrian refugees. But at the same time, there are regional enforcements. Regional enforcements such as the obligation to respect the rights of refugees articulated in the European, what we call, Convention on Human Rights, or 1969 Convention on the Organization of African Unity, which is popularly known as the OAU Convention. Therefore, it appears that, and it is at the same time clear, my dear friends, that the once recognized as a refugee, a person has a significant array of rights that are protected, that are recognized, that are advocated under customary international law. And that basically gestates a question: why the rights of Syrian asylum seekers are not protected? Why the rights of Rohingya refugees, when they are seeking asylum in their neighborhood or beyond a neighborhood, are not what we call recognized? It is evident, my dear friends, from this entire what we call legal labyrinth of these what we call or from the quagmire of this two refugee crisis. Numerous media sources have also mentioned, and many of them have suggested, that the answer, my dear friend, lies in the way refugees are defined under the current legal framework. And the definition under the current legal framework is not at all adequate in providing or entailing any kind of a penal consequence for the geopolitical entities. And this has created not only the refugee crisis, my dear friends, but at the same time, it has also what we call, created a crisis of international refugee law. I would not be going into the detail because, again, otherwise I would be taking to all of you to the definition clause. And this is something we have already deliberated. And therefore, my dear friends, it becomes very, very important to understand that the policies and the policy recommendations must be formulated. Because as of now, what we have been witnessing in the entire understanding of international refugee law, and particularly in South Asia, we are basically dealing with refugees with the help of the constitutional provisions. It is the, right to life constitutionalism with which we have been dealing with refugees. It is the dignity jurisprudence, equality jurisprudence, refugee constitutionalism. And this has been produced by the highest judicial establishments in our part of the world, and that is South Asia. So we are able to defend refugees. Otherwise, we do not have any kind of a refugee specific legislations or law in our part of the world. Because the biggest lacuna which I find in the constitutional schematization of South Asia, that we do not pay adequate regard to international treaty obligation via our constitutions or in our constitution. try to evaluate my line of argument. We have basically, designed policies. And as a student of, law, we should be very careful when there is a question of, policy. Because the policy is a territory which should be addressed as a terra incognita. Policy is a domain which is impregnated with the idea of volatility. Policy is a framework which creates instability. Policy is basically addresses only one idea, and that is the political expediency. And policy provides a framework which does not entail anything for the future. And in case it is the future of refugees. Therefore, I have identified certain important policy recommendations. And these policy recommendations constitute a very, very important addition, though there is nothing final, my dear friends. And I am not going to have any kind of a finality. Because if today I am going to have any kind of a finality in my submissions, then it is going to be a disintegration of my academic thinking. You have every right to disagree with me on these, policy recommendations. And the number one, policy which I have, framed, my dear friends, that is relating to countries in North America and some in Europe and the Pacific have expanded the traditional readings of the refugee definition as contained in Article 1A, Para 2 of 1951 Refugee Convention to include persons fleeing persecution in situations where the country of origin is unable to provide effective protection or no longer exists. That line should also be reflected in South Asia and Southeast Asian municipal legal systems, so that we should be able to address refugee crisis in our neighborhood. I am talking of a Rohingya refugee crisis. Second important policy recommendation, my dear friend, is that the breakdown of public order, internal strife, civil war, ethnic cleansing, and genocide are increasingly the cause of refugee movements in this part of the world. Therefore, it should be legally addressed. But I have not incorporated another important, dimensions to this argument. And this is a dimension, my dear friends, and I tender unconditional apology for identifying this particular, aspect. And it is equally applicable in our part of the world, that is the SAARC grouping. Though to a very great extent it is having a universal understanding. If you take into account and try to identify, try to diagnose what exactly are the causes of refugee migration worldwide at international level, then I see three important dimensions. In majority of the situations, refugee migrations are driven or triggered by, number one, by hate, by religion, by political opinion. And you will also, appreciate this diagnosis of mine. Then in majority of the, refugee situations, whether, mass refugee exodus is there, whether the mass refugee influx is there, or massive what you call, migrations of refugees are taking place, they are basically or have been triggered by religion, hate, and political opinion. These are the three important causes, though there may be some incidental causes, connected causes, vicarious causes, collateral causes, and the fringe what you call, causes. I am not denying, or there may be some separate what you call, causes. And one of the, causes has recently, emerged, and particularly after the, adoption of the Stockholm Declaration on International Environment, or in the area of international environmental law in 1972. Stockholm Declaration. And since then we have been addressing and recognizing the issue of environmentally displaced persons, and we have addressed them with a new kind of a nomenclature, and that is known as the climate refugees. But so far the humanitarian refugees are concerned, or the political refugees are concerned, because their community of scholarships or community of scholars have come out with various what we call, nomenclatures to address. But so far, my understanding is concerned. This is my, diagnosis. But at the same time, also, I am also having my prognosis about, refugee situations that will, at a subsequent stage, I will share with all of you. Therefore, in this situation, United Nations High Commissioner for Refugees sensitize religious heads, monks, ulemas, imams, priests, popes, spiritual leaders to understand that every religion respects democracy, human rights, multiculturalism, diversity, as an inalienable part of human existence. It should be the part of our policy framework. And the same must also be inculcated in the entire administrative hierarchy and structure of a nation state, so that they should be able to deliver structural justice. Because majority of the violations in the country of reception are basically committed by the architecture of structural justice. UNHCR, or the United Nations High Commissioner for Refugees, must look beyond the trajectory of improvement of care and maintenance of refugee aid and assistance for Rohingyas and other refugees in the South and Southeast Asia. UNHCR further, my dear friends, liaison with the national governments in Southeast Asia to find durable solutions to refugees' plight and get them codified in the national laws, and particularly it becomes imperative on the part of the national governments in the post-global compact on refugees and migrants. Another important policy paradigm that must also be reflected upon, and that should also be appreciated on the critical footing, that the international humanitarian intervention must be free from any quid pro quo. Quid pro quo means there should not be any kind of a give and take kind of a consideration. There should not be any kind of a lobbying, caucus calculations, and national policy paradigms, etc. There must be equality in readdressing, redressing, and mitigating human sufferings rather than geostrategic importance of a particular refugee-producing region or country to be the criteria to warrant solutions of the refugee problem. Because it is axiomatic from the behavior of the South Asian nation states that they are comfortable with some refugees and they are uncomfortable with some other refugee groups. Pakistan is comfortable with that of Afghan refugees. So primarily the element of religion is functioning in favor of refugees, in favor of hosting nation state. Even in Sri Lanka, they are comfortable with refugees of Buddhist religion. But they are they are not comfortable with other what you call religious denominations. But to a very great extent, my dear friends, India as a refugee hosting geopolitical entity has maintained to a very great extent at the initial years of its independence. It has extended without any discrimination. It has hosted refugees without any kind of discrimination, even in the absence of a refugee law. In 1959, Government of India has extended and received Tibetan refugees. A huge population of the Tibetan refugees have been living since then in India. And almost they got themselves integrated with that of the local population. Their living has also become the part of an integral cultural or the culturalism or the composite culture of India. India did not discriminate in case of Afghan refugees. At the same time, again, if you take into account the question of the Tamil refugees, again, India did not resort to any kind of discrimination. You are in a better position to appreciate why no discrimination has taken place. Because of the secular character of our polity, because of the political implications, particularly in case of Tamil refugees. But of late, there has been some changes in the refugee policy, and that is why I always go for a legislation, a refugee specific legislation, whether it is going to be a good legislation or a bad legislation. It is not a question, but there is a question that we must have, and we should try to have a refugee-specific legislation in India. Because of late, it becomes more important in the current, what you call, circumstances where even the judicial establishment of India has started unsettling its own, creativities of the past. Judicial establishment in India is not upholding the pervading line of argument, a perennial line of argument which has been judicially decided for the protection of refugees in India. Therefore, we should try to have a relook. Since the inauguration of the Constitution of India, since the inauguration of the Constitution of Islamic Republic of Pakistan, and since 1971, even Bangladesh must also reflect upon its refugee policies. And that is why international community, my dear friends, must calibrate and craft a credible and pragmatic international pressure mechanism to the refugee problems backed by sanctions against the refugees producing countries. Moreover, human rights bodies have had to assume a role they were not initially meant to play, as they are now dealing more frequently with cases relating to asylum. At the same time, my dear friends, no country of refugees is capable of facing great difficulties in handling refugee influxes at its own. So that the principles of burden sharing, which has now been presented in the global compact as the international responsibility sharing, is, and that should also be incorporated in the national legislations, which implies that the international community will help to relieve the burden placed on the country of what you call reception. Because there has to be an element of solidarity with the refugee receiving countries, refugee hosting countries, or the country of refugee reception. The stratification of refugees on economic, climate, humanitarian, and political grounds, my dear friends, must be incorporated in the scheme of existing refugee definition wherever it is or whenever it is likely to be reformulated or redefined by adopting an additional protocol to 1951 convention. Or if a national government is going to what we call, adopt a new kind of a legislation. Because we have also witnessed the entire legislative exercises in the United States of America. In 1924, in 1962, in 1965, in 1980, various steps have been taken by the US Congress. And unfortunately, we have also witnessed how the rights of refugees were violated. The rights of immigrants have been violated by the Trump administration. When the ex-president of the United States of America has invoked a very, very archaic kind of legislation of 1924 and denied entry to those refugees. He did not bother that there are legislations which have been subsequently passed in 1962, in 1965, and there happens to be a Refugee Act passed by the US Congress in 1980. But he invoked an earlier piece of legislation. So what kind of a political chicanery has been demonstrated? What kind of a political subterfuge has been committed against the refugees by the Trump administration? So there is a lesson, my dear friends, in these administrative what we call measures taken by the national governments. And that is why policy is not going to serve any kind of purpose, and therefore there is a requirement that we must adopt a very, very important what we call criteria, and that criteria must also be incorporated within the national legislation or legislative exercises. My dear friends, refugees are being regarded as subjects of international law, and there is no doubt about it. Therefore, states should not perceive refugee flows, refugee exoduses, influxes, migration, and transmigrations as a threat to the sovereignty, integrity, and national security of any specific nation state. Theories of pushback and imposed repatriation must at all levels be avoided. Rather, principles of non-refoulement and the institution of asylum must be promoted and preserved as it has been required under Article 14 of the Universal Declaration of Human Rights, and same must be the part of what we call the national legislations in South Asia or anywhere in the world. Because the fate and future of refugees are not the sole responsibility of the United Nations High Commissioner for Refugees alone. Rather, it is an enterprise of humanitarian character and philanthropic engagement, which involves, my dear friends, partnerships of all national governments, development advocates, humanitarian actors, non-state actors, all organizations like International Organization for Migration, international non-governmental organizations, and they have to function in tandem with UNHCR. Therefore, national legislations in every geopolitical entity must underline the fact that there is an unqualified universal mandate to protect refugees of all castes, colors, genders, opinions, races, and religions who are fleeing well-founded fear of being persecuted or fleeing what we call well-grounded what we call persecution. So in such a situation, we must what we call incorporate these policy paradigms in any kind of a legislative exercises coupled with the UN Global Compact provisions in these, Global Compact on Refugees and Migrants must also be the part of the national legislative engagement and exercises. So it is, my dear friends, equally important for Syrian refugees, for Rohingya refugees, that we must, reflect upon on these what we call, understandings. In this connection, South Asia's treatment of asylum seekers and refugees immensely incompatible with global standards, as it does not have lex lata on refugees, and at the same time, South Asian jurisdictions, South Asian nation states are not inclined to have any kind of a lex ferenda so far the refugee protection is concerned. South Asia, my dear friends, deals with asylum seekers and refugees, and the majority of nations, since they have been the part of the British Empire, so they adapted a colonial legislation which is today known as the Foreigners Act of 1946 or 47, which does not have even the most minimum content of the definition clause of 1951 UN Convention on Refugees. Because the Refugee Convention of 1951 incorporates well-founded fear of persecution. And that is the most important, paradigm to determine, because well-founded fear of persecution is the litmus test. Litmus test for the refugees, and to determine their, protection threshold. Because in South Asia, the Foreigners Act of 1947 or 46 simply prosecutes and treats aliens and migrants as only foreigners. And the Foreigners Act of India, Bangladesh, Pakistan, this is a piece of legislations is brutally inadequate, flagrantly inhuman, and gives unfettered powers and executive what we call discretion of the deporting migrants and refugees to the national governments. It is now the best what we call opportunity for the South Asian nation states, my dear friends, to demonstrate the political will, and they should go for enacting law on refugees at national and regional levels. Otherwise, we would never be in a position to demonstrate, we would never be in a position to confidently demand any role for addressing international issues. If we are really interested to understand international implications for the refugee protection, then it is the responsibility of the South Asian nation states. Because majority of the nation states from South Asia, particularly India and Pakistan, today they enjoy the membership of majority of the international organizations, and they have been the part of the majority of the multilateral international organizations, in addition to United Nations organization. And basically, if we are going to have the national legislation in our part of the world, then definitely it is going to what we call, provide continuity, stability, and dignity to the refugees. And at least it is going to minimize the role of the non-state actors. It is going to what we call the minimize the threat of what we call threat to national security. It is going to what we call mitigate the crimes what we call like organized crimes of human trafficking. And many other important incidental problems are likely to be addressed if we are going to have a national legislation. There is another important dimension to it, and that is basically, that takes me again to the Syrian refugee crisis. In this particular scenario, whatever the deliberations we have undertaken today, we should apply these cumulative understanding to the Syrian refugee crisis, to the Rohingya refugee crisis. My dear friends, at the very outset, as I have submitted, that the Syria has been facing an ongoing and severe crisis for more than what we call a decade. Since the beginning of the Syrian refugee crisis, the forgotten, victims have been women and children who have faced hunger, harassment, death, and trauma, and have been deprived of the benefit of humanitarian aid, and they have been, surviving and languishing in misery. The degree of their, suffering, the threshold of their pains, have been what we call, insurmountable. And the effect of terror is even more important for children who, because of the short nature of their lives, feel the brunt of what we call of a decade of years more than what would face an adult. This year, this entire one decade that we started in the month of March in 2011 have been transformative for children who are often moving from one place in life to another place in this lifespan. This decade could have proven to be a lifetime achievement for high school students, thoroughly preparing themselves to contribute constructively to their society. But the children in Syria are deprived of these accomplishments, achievements, feelings, and this is the most minimum continuum of their rights advocacy. In this past decade, Syrian crisis have been the longest what we call crisis. They are confronted with loss, despair, depression, non-belongingness, sufferings and pain. It has been immeasurable. And they have been living in this sorry state. And that really creates the most damaging aspects of conflict that ultimately even decimated the children or the child community in this particular debate. We should not forget the international implications of the Syrian refugee crisis. Because the Western powers have always been in search of natural resources. And the most what we call, a sham facade of these Western powers have been the advocacy for human rights, constitutionalism, rule of law, judicial review, social justice, equality, fundamental human freedoms. These are all preposterous arguments, sham arguments, hollow arguments. Because this reminds me of a very, very important asseveration, what has been stated by a thinker, Cicero, that if you scratch the civilization, you will find dirt. And again, I recall one of the most important quotation from the Shakespearean tragedies. And one of the tragedy has been written by Shakespeare, which is known as today as Macbeth, where Lady Macbeth is coaxing her husband, Macbeth, and she is what he call, teaching a lesson to Macbeth how to behave publicly. And I quote, my dear friends, and she says, that look like an innocent flower, but be the serpent under it. So you can very well understand, and this is how I think the entire global North nation states have emulated this particular Shakespearean quotation. And today we can see so far the nation states from the global South geopolitical settings. That 1951 UN Convention relating to the status of refugees with its additional protocol of 1967 is a Western project to deny human rights to refugees. I am sorry, this is something I am what you call sharing my own personal wisdom. But at the same time, my dear friends, I am amenable to corrections. When I witness the proceedings of the international multilateral organizations, then all the multilateral organizations of international character are dominated by global North nation states. So basically what I have been witnessing, that the entire world has become a hostage to the global North nation states. Because the global North nation states, via these international multilateral organizations, have been deciding what should be there for the rest of the world. Take the example of refugee rights. It is the Western world who has decided that these are the causes of human displacement. In case of climate refugees, it is the Western world which has created hostile situations, who has pumped lot of what you call gaseous emissions, hazardous what you call gases. It is the Western world who has depleted the ozone layer, and they have ultimately made humanity to what you call migrate from one place to another place, resulting into a new class of refugees known as climate refugees. What kind of a governance architecture should be what we call embraced by the respective national governments or the national identities, as well as the geopolitical demarcations. They have presented before rest of the world what kind of a democracy should be there, what kind of a democratic institutional framework should be there. They have decided for the rest of the world. It appears that everything is being what we call decided by these nation states. They are not at all worried what are the feelings, what are the preferences, what are the priorities, what are the potential models which have been envisioned and contemplated by the global South nation states. So they are not at all worried. And it is the majesty of the global South nation states that they are arguing that our creation of refugee rights, our what we call enactment of a refugee definition, our idea of what we call of understanding of the refugee law, that should be taken as a complementarity. We are not getting these kinds of advocacies from the scholars of the global North nation states. There may be some exceptions, but these exceptions should be treated as an aberration. Whatever has been contemplated so far, the world economic order in the Bretton Woods institutions, which resulted after the Bretton Woods Conference of 1944, we have been what we call subjected, within inverted commas, what I call, my dear friends, prescriptive international law. So I do not buy this argument that whatever has been originated, whatever has been prescribed, whatever the creations we have been witnessing in this world, if it is having some kind of an origin in the Western nation states, should be treated as the most euphemistic utopian, which makes this particular world a place full of hunky-dories. No. I totally reject this particular argument. And that is why we must try to understand international law. Raj Gopalacharya, rightly what he call, I'm, a little bit, confusion in his name, but he has contributed a very, very important book, International Law from Below. It means international law from the perspective of the global South nation states. We must have a South Asian orientation of international refugee law. We must have an Asian orientation of international law, because the international issues have been there even before the Hugo Grotius. Whatever the prescriptions we have been having in the writings of Socrates, in the writings of Plato, in the writings of what we call of other thinkers, governance has always been there. We have also governed ourselves in those ancient times, or before the Christ. Even in that in antiquity, we were not without any kind of governance architecture. Asian countries have been governing. Various empires have also what we call created a central authority. Provinces have been created where the governors have been appointed. But my dear friends, I am sorry to say that I am not in favor of, I am not a votary of the current international law, which I call as a prescriptive international law. We must have our own understandings. And why it is prescriptive international law? Because our natural resources have been controlled by the Western what we call companies, Western firms. And the legal field is not an exception. Even today we are witnessing a new kind of what we call intervention in the name of artificial intelligence. That has again going to what we call further advance the cause of prescriptive international law. So when we are talking of refugee crisis, refugee crisis is not merely a refugee crisis. When I am talking of Syrian refugee crisis, this does not mean, my dear friends, that it is a question of international refugee law alone. Yes, it is a question of international refugee law. But what kind of an international refugee law we have been talking? Why we are not talking of other important implications of these refugee crisis? What has been the role of the Western nation states in these global South nation states refugee crisis? We have to understand what has been the role of the United States of America in Syrian refugee crisis. Who are the international actors? Who are the non-state actors patronized by these Western powers? Why the global South nation states have become the laboratories to test the newly manufactured weapons from global North nation states. All kinds of weaponry was tested in the Gulf War first and the Gulf War second. That has also produced refugees. Whether it is the Korean War, Vietnam War, these Western powers have created and produced refugees. What happened when the Mujahideens were flushed out Russian armed forces from Afghanistan in 1989? Who was responsible for that? Who created these Taliban? Who has created ISIS? Who has created Boko Haram? At regional level, who has created these kinds of organizations who are indulging in proxy wars in South Asia? Who has created? Who was the creator of LTTE? There are umpteen numbers of international organizations who branded themselves as the liberation movements, but they were basically the part of terrorist activities. But who funded their terrorist activities? So we should not be the part of what you call of this kind of a prescriptive international law or prescriptive international refugee law. Rather, we should evolve our independent idea of cosmopolitan international law, an international law which is going to be inclusive, and we should not be the part of this kind of a Occidental orientation of international law, or the international law that has been prescribed by the Western nation states. And that is why we have a different, so far Orientalism is concerned, we are having a different idea of democracy. A democracy which is based on parity, inclusion, multiculturalism. But at the same time, I am not what you call giving any kind of a certification, or I am not certifying that whatever the fundamental principles of governance which have been evolved over the years in our part of the world are quite right or correct. No. We must have some kind of a self-introspection as well, and there has to be an improvement roadmap. But whatever has been prescribed by the Western what you call nation states, that cannot be and South or global South nation states must not allow themselves to be taken for a ride by the nation states who consider themselves as sitting above the rest of the world. So with these perspectives, we should try to evaluate entire Syrian refugee crisis, because we cannot decimate the role of the Western powers, whether it is the Russian Federation, United States of America, or the major what we call members of the North Atlantic Treaty Organizations known as NATO. Now, I invite your questions. Any questions? Well, dear friends, Syrian refugee crisis has also impregnated with certain important questions. Weapons of mass destruction has become an issue in Syria as well, particularly between Syria and US relations, because it has been alleged by the United States of America that Bashar al-Assad administration is indulging in developing chemical weapons. Even the similar allegations, or the same allegation was also leveled against late president of Iraq, Mr. Saddam Hussein. In case of Iraq, and I believe there is an iota of truth in the allegation of, again, Bashar al-Assad of Syria, that it has been the part of a larger what we call program, a larger political conspiracy hazed by the Western what we call nation states, led by United States of America. And basically, if you take into account any international conspiracy, all the conspiracies, barring few exceptions, are basically of an economic nature. When when we see the reasons why the Iranian revolution or Islamic revolution in Iran in 1979 has been successful, then there were economic reasons. Because at that point of a time, the Shah of Iran was simply a puppet in the hands of the British and the US what we call governments. It was the British and American particularly the British oil companies who were exploiting, controlling, dominating the natural resources of Iran, and it was primarily the oil. If you take into account the latest what we call persons of the United States of America in Saudi Arabia, you will find that all the oil refineries all the, oil producing or oil, what you call, extracting, companies are hailing from United States of America. And therefore, this allegation has not come out without any kind of a substance. And the allegation is, and we can further what you call, substantiate from the history, that the Western powers have always been interested in exploiting the natural resources of the global South nation states by dividing them, creating new political maps, manufacturing some kind of a sham apprehensions, redrawing of the geopolitical entities, creating new geopolitical maps. And this is something we have also, witnessed during the, Roman Empire, Byzantine, Empire, and other important, empires exclusively controlled by the Western powers. Natural resources have always been the destination of these, nation states. And in between, they have, produced a lot of, human mobility, or we may call them refugees. So therefore, there is a, need, my dear friends, to understand the causes, the role of international actors, role of international nation states, how they have, played and facilitated, supplied, and what has been the agenda of their humanitarian interventions. Then only we should try to appreciate, because at the highest level of LLM program, we cannot buy some kind of a theoretical, what we call, prescriptions. Yes, there is a, convention, there is a violation, and these are the, population of refugees. These are, this much of, refugees, these are the numbers of refugees. This is how we can't understand. If we are having this kind of a, easygoing, what you call, approach, then basically there is no room. If we are, invoking these kinds of what you call of, arguments, there is no room for any kind of a further research. What is important is we must try to understand the repercussions, ramifications, manipulations, political angles, theoretical what you call, constructs, and historical roots, philosophical foundations, how the philosophical foundations of the Western orientations ultimately created an army of, thinkers who have designed the roadmaps for the exploitation of the natural resources of the global South nation states. This is how we should try to understand the idea of refugee influx and refugee exodus. There is something in the chat box. Yes, Muhammad Imran has come out with a question: who gets the right to complain against a state that violates the principle of non-refoulement? My dear friend, Mr. Imran, it is a very, very important question, though every question is very important. There is no state who grants rights. It is the conscience of a state that grants rights. In case of Rohingya refugees, my dear friend, it was the state of Gambia who came out with a complaint. A state can complain against a state, and today, even an individual has also been empowered under procedure 1503, and with the same name, that is a resolution of the United Nations General Assembly that has created a framework to complain in case of violations of human rights, in case of what we call the violations of the individual autonomy and the incidental rights like the right to dignity. Similar analogical deduction is also available to a state. And therefore, there are some advocates right now who has been working, and they are preparing the brief to file a case against the state of Israel in the International Criminal Court. Because there is a community of lawyers who are arguing, my dear friends, that Israel has committed crimes against humanity and crime of genocide. There is another, second important community of lawyers who have been, working ever since or for the last 1 week when this new what we call, conflict has started between Israel and Palestine led by Hamas. So they have also, argued that even Hamas should also be, taken to the International Criminal Court. And they are preparing the legal grounds under international law for the same. So it is the, state, while exercising its sovereign will to complain against a, state. Because violation of non-refoulement, Mr. Muhammad Imran Sahib, is the violation of a plenty of human rights. In my personal individual understanding, when a state violates this particular, article or principle, as you have, asked in your question, the violation of the non-refoulement, I see it as a massive violations of human rights by a state. So individuals have been empowered to complain before the international judicial establishment, and a state may also plead before the international judicial tribunals that such and such a state is in violation of the principle of non-refoulement, because non-refoulement is not the discretion of a particular geopolitical entity. Non-refoulement is a fundamental norm of customary international law which is applicable to the entire humanity in the form of geopolitical entities habitating this beautiful planet. Are you getting my point? So a state can argue, can go for and get redressal. And the best example which I have given, because there are cases, whether it is the state of Gambia, whether the state of what we call the litigation between India and Pakistan before the International Court of Justice on the Jadhav case, or some African what we call cases before the International Criminal Court, and the latest what we call violations of the civil liberties of people of the two nation states, Israelis and Palestinians. So this is how it should be what we call attended.
Sir, may I just add to this question?
Yeah, please, most welcome, most welcome.
Sir, when a state is forcing a group of people from territory, it is simple. I mean, the violation of the whole plethora of rights under human rights and other international instruments. But I'm asking especially with reference to Indian Supreme Court's decision. I mean, we know that the Supreme Court decision to deport Rohingyas was a violation of the principle of non-refoulement. In that, I mean, it is not, I mean, specifically related to India. I'm giving an example that
let me admit, yeah, you will complete your, please don't
yes,
forget.
Sir. So, in
I
case...
was deliberately avoiding.
Yes, sir. But
But
the
you
question
are
is,
forcing me to come to this particular aspect as well.
but the gist of the question is, when a state is violating a principle of non-refoulement while hosting refugees, who gets the right to complain? I mean, whether those refugees can complain in ICC, or I mean, not in ICJ because it does not host such cases. Can the refugees, as an international person, directly claim, or since it is a non-refoulement principle, any country who is member of UN can claim in ICC? Because the Gambia case is related to genocide convention and then other convention. Under customary international law, can we complain that X state has violated that right? So in ICC, yes, sir.
There are two important stages, my dear friend. Number one is, we can plead in a geopolitical entity in case of violations of non-refoulement. We can plead before the constitution bench, a full-fledged constitution bench, and we can request, because there are questions of law which are involved, and the questions of law of a constitutional character are involved, and therefore this requires the constitution of a constitution bench. We can also, in case of violations, because it is not only a violation of human rights, but since it has become the part of the customary international law, so the customary international law by implication is the part of what we call of Indian constitution, or the constitution of United States of America, or constitution of Gambia. So it does not mean, when we are talking of violation of customary international law, so when we are talking of violations of customary international law, it does not mean, my dear friend, that there has to be a international what we call court of justice statute. Yes, that may be an enabling what we call provision. But when we are pleading in the name of customary international law, we can also argue, since it is a fundamental principles of the customary international law, and we are living as a part of the civilized nation states, and therefore this fundamental principle is common, and it is also available in the scheme of the Indian Constitution, and therefore we can also argue in the name of the customary international law before the municipal legal system. That is one important argument. But at the same time, there is another important argument. We are having the 9 core international human rights treaties, and the obligations which have been contemplated under these treaty obligations, or as a part of the treaty obligations, the non-refoulement is also the part of these treaty framework or treaty obligations, or as a part of the human rights framework. And therefore Government of India has also signed, acceded, though it has not ratified, it has not submitted its instrument of ratification to the Secretary General of the United Nations organizations under the UN Charter, but it is a part, it is privy to 1984 UN Convention against torture and degrading treatment and punishment. So therefore, it happens to be in violation of Article 3. So that, to a very great extent, empowers what we call the judicial mind, a larger bench, because we can go in review, we can go in appeal, we can also plead before the International Court of Justice. But after the exhaustion of all the local remedies, an individual, even from India, can also go for international what we call judicial establishments for the redressal of his or her grievances. That is the legal position. Any further, any supplementary?
No, sir. Thank you.
Yeah, please. Somebody else is also willing to say something. So, in case of Syrian refugee crisis, if you see at the regional level, the biggest casualty has been the peace. Because whenever the peace does not prevail, it results in majority of the circumstances in the form of war. We have, witnessed Iraq war of 2003. We have also witnessed the failed Israeli and Syrian peace process. We have also been witnessing failed West Asia peace talks, which is between the Palestinians and Israelis. We have recently witnessed Arab Spring. We have also, witnessed Arab Cold War. We have also, witnessed the sanctions invoked by the Saudi Arabia and imposed on Kuwait and Yemen, and what kind of a role Arab nation states, particularly Saudi Arabia, has been playing in Yemen. At the domestic level, my dear friends, we should not forget that the Arab world has been witnessing the failed economic liberalization. And some of the Arab nations are basically reeling under the economic sanctions. And this economic, crisis has also generated a decline in subsidies to the populations. Because of the US sanctions, the prices of oil to a very great extent has plummeted. But we have at the same time, my dear friends, also witnessed the revival of Islamist and radicalization, or radicalized what you call, Islam. And that particular, started in the year 2004. And since 2004, we have been witnessing in the Arab world, my dear friends, attacks, conflicts, assassinations, clashes with military groups and among the what we call, military groups. In 2004, 2005, 2006, 2007, even 2000, what we call 8 and 9, political leaders as well as, moderate religious clerics were what we call, targeted, and rather we started witnessing the targeted killings in this part of the, world. And that is, and among them, the Syria has always been prominent, what we call, entity. There are many important, groups, military groups. Military groups in Syria who has been, operating with what we call, different names, like Islamic State in Iraq and, Levant, that is ISIS. Al-Nusra Front is also there. Islamic Front is also there. Revolutionary Front of, Syria. And Syrian Military Command or Free Syrian Army. These kinds of, groups have been, operating. As I have, submitted a moment ago, that the international refugee migrations are basically caused by hate, religion, and political opinion. And my dear friends, the Syrian refugee crisis is the victim of politics. It is a politics-induced refugee crisis. It is a crisis, my dear friends, between forces loyal to the Syrian Ba'ath Party government and those seeking to oust it. Protesters primarily have been, asking for the ouster and resignations of the incumbent president of Bashar al-Assad, whose family has held the presidency in Syria, I think since 1971. They have been what we call, ruling. And it is a rule of more than 50 years. And they want the banning of the political party, which is known as, Ba'ath Party. So it was basically a politics-driven refugee mobility. Therefore, hate, religion, and politics, or the political opinion, these are the three important, factors. And the same factors have been applicable or have been what we call, prominent in the displacement of the Rohingya refugees from Myanmar. Therefore, in this kind of a situation, whether it is Six-Day War of 1967 between what we call Syria and Egypt on one side, and other side, or the opponents, what we call side happens to be Israel. Then the Yom Kippur War of 1973. Then the Lebanon occupation. Then other important what we call prolonging of war, and that was also encapsulated entire Lebanon. Then it also is spread to Jordan. But what is the solution? What kind of a solution should be contemplated? I will share my own conclusion with all of you, but you should also prepare your own conclusion. What exactly we have what we call taken away out of our deliberations of today. For the last 2 days we have been deliberating these two important what we call crises. And at the same time, I would like to what we call draw to your attention to have an evaluation of 1951 UN Convention relating to the status of refugees with its additional protocol of 1967, one particular argument, and the second argument what has been the contribution of the two UN Global Compacts of 2018, and cumulatively we have to draw our conclusion. And for that, I would also be sharing few readings with all of you. I also take this opportunity, my dear friends, to wish you all the best for your ensuing examination. That is the end-term examination. May I know the date when you are having your international refugee law examination? Imran sir? Anybody? Yeah, Jamshed sir.
Sir, actually 11 June, I think, sir.
Okay, on 11th of June. Thank you, Ehtasham bhai, Jamshed sir. So up to 11th of June. So how many days left? Almost a month. Or 20 days or 22 days. So from tomorrow you are going to have your preparation leave for international refugee law examination. Meanwhile, if you are having any confusion, if you require anything, if you demand anything, if you want further what you call, clarifications, if you are willing to share some observations, or you want to make some comments, whatever we have, deliberated in these 11 what you call, weeks, then your observations and your comments and critiques would also be the part of what we call of our, week 12, where this week 12 has exclusively been devoted and designated as a part of what we call of these, comments and observations. You can critique international refugee law, so you are going to be most welcomed. But before I take your leave to leave today, let me what you call, point out, you are going to, so far the question paper is concerned, you are going to attempt 4 questions out of 10 questions. Is that okay?
Yes, sir.
Okay. So out of these, 10 questions you have to attempt, or there may be 12 questions. So you have to attempt only 4 questions. Each question would be of 25 marks. This is a very, I mean, in a nutshell, my submission regarding your question paper. I have also a request for my students who are, working on their dissertations under my supervision, that if they want to, if they are willing to have an online session for interactions regarding their dissertations, regarding what we call dissertation related issues. So I can also share a link with all of you. There are as many as 4 or 5, students. So we can also, meet online, and I can share, and you can discuss each and everything regarding whatever the issues are there. If you confront with any kind of a disconnect, if you are having some theoretical what you call, questions, if you are having some other, problems which is relating to your, dissertation, before it's what you call, official submission, I can organize online meetings with all of you. And previously also I have, organized, such meetings, and fortunately, only one student, and I'm immensely thankful to that very student. I'm talking of Mr. Mohammad Imran. He has attended those online meetings on dissertation deliberations. So please, you should be very careful about your dissertation, submissions. And I also take this opportunity to pay my gratitude to all of you that you have given me a very noble opportunity to serve you. And for the first time, despite the ongoing global pandemic crisis, for the first time, highest number of students have opted for international refugee law. So it's an achievement, at least. And I really, pay my respects to your magnanimity, for your generosity, for what you call your interest in this particular, branch of human cognizance. And I will keep on, sending you some important, material which I have, identified in the last 1 month, but that material would not be the part of your class deliberations. Because international refugee law has over the years has established itself as an independent branch of research. And in this year, even 1951 UN Convention relating to the status of refugees is going to complete its 70 years of its existence in the coming month, and that is July, on 28th of July in 2021. So I request you that you should also contribute to something in the form of a blog, in the form of some, writing, how this particular, what we call, convention has completed a long journey of 70 years. What has been the confrontations or various stages which has been experienced by the refugee rights defenders in implementing, and to what extent the governments have been sincere in implementing the mandate of 1951 Refugee Convention in the last 70 years of its existence. So I wish you all the best. Feel free to contact me at any moment, at any time. And meanwhile, if I'm not getting any kind of a response from your side, and since you are keeping mum whenever I share anything with you, I do not get any kind of a response. So I will keep on sending and what you call enriching your inboxes. I would be sharing a lot of what you call books and other research material in the area of international refugee law. So thank you very much for being with me. But at the same time, I apologize if I have committed any kind of a wrong. So I tender an unconditional apology, and at the same time, I am immensely thankful to your cooperation, to your support, and to your compassion. You have been very considerate, very accommodating, and very what you call soft-hearted. So thank you very much for everything. All the best. Thanks.
Sir,
Thank you so much, sir. It means a lot.
Yeah, thank you.
sir, I have just one request.
Yeah, please.
Sir, Mr. The word limit for questions, I believe that was very long. So since it will be 4 questions, is it possible to reduce the word limit?
Yes, it is
If
all
you
up to
think
you.
that is possible.
I leave it to your fine sense of judgment, but in the question paper itself, I will also reduce in writing.
Yes. Thank you, sir.
Word limit as well. Yeah, very good.
Thank you.
Thank you
so
very
much.
much. You're welcome. Thanks.
Thank you so much, sir. Thank you so much. We are truly obliged, sir.
Thank you so much, sir.
Thank you, sir. You're welcome, Masud Bhai. Mr. Pratim Allah, thanks a lot. Yeah, thanks a lot for your kind words, Ms. Prakriti. Thank you.
Thank you so much, sir. Thank you so much.
You're welcome, ma'am. Thanks a lot. Yeah, take care. Bye-bye.
Thank you so much, sir. Thank you so
Thank
much.
you.
And I
Thanks
am
a lot, Jamshed Bhai. Thanks a lot, brother. How are you? Good?
sir, good. I am good, sir. I am really happy to see you,
Yeah,
sir.
you're
That
looking very beautiful, very smart one. Yeah.
no, sir, it's not about. Yeah, of course. Why should not I say that myself that I am smart?
Yeah.
I need some reason to be happy.
Thank you.
Yes, sir. Actually, yes, I really thank you, sir, because of this situation. You know that you have been really consistent, and we know that you are also face lots of things meanwhile. But yes, sir, that was really good.
Jamshed Bhai, let me remind you, I can face anything in my life if my students are with me. You are my strength. Students are an asset for a teacher. If my students and I'm getting the support of my students, I can do wonders in the world.
Oh, then thank you, sir. Sir, it's a matter of sir. We are literally, sir. We are really obliged to you, sir, that you have been really consistent, and we are really happy that lots of these students chosen this subject as a refugee law and growing trend of refugee law.
Yeah.
And I would like to inform you, sir, that I most possibly I will be here in Delhi even after leaving SAU. So it is not that we are going somewhere else. We are most possibly will be in here Delhi, and surely I
So
will
I
be
invite you at my residence in the post SAU scenario when you happen to be here, and definitely I would be rather providing you an opportunity to do some co-authorship, some research engagement, and some other important academic activities should also be our priority. So I will not leave you if you are in Delhi.
Sir, actually, Imran is saying, sir, I will come to your home for having biryani. So
yeah, definitely, most welcome. I will offer, because there would not be at that point of a time after accomplishing your degree, of LLM, there would not be any kind of a conflict of interest. So
Yeah.
when you are having your mark sheet in your hands, your grade sheet in your hand, and thereafter we are meeting on on family occasions or in the name of socialization and interactions, we are indulging. Academic interactions, research oriented interactions are likely to take place, then there would not be any kind of a conflict of interest, because prior to that there are a lot of what you call apprehensions.
Yes,
So
sir.
no apprehension would be there.
Actually, one of our colleague is Nazneen Raisina.
Yeah,
And,
yesterday I responded. No, day before yesterday I have responded to her, email.
yeah.
Yeah.
So
So we are here,
yeah,
brother. Don't worry. So further relaxation may also be, given, and as a specific what we call, case, as a specific situation, because this is not only a medical situation, but it is a extraordinary medical situation. So we can extend. So this relaxation should always be there. So with the help of and under the guidance of the Honorable Associate Dean, I would be doing everything. And from my own side, I am definitely make her submission of dissertation quite possible.
yes. Actually, sir, yes, sir. Lastly, sir, I would like to say, sir, that I will also seek, sir, apologize if any that things
No.
or have for me, and as a student, that is really honored to be your student. That is, it is literally.
It is likewise. I am fortunate enough. I am very lucky to have you guys as my students. And
Yes.
we have been telephonically talking on academic issues, on research issues, and I will keep on continuing. And still one important aspect still remains to be deliberated with you, and that is your career trajectory
Yes.
from LLM onwards. So we will be talking on that also. That issue still remains to be discussed. Yeah.
Yes, sir. Okay, sir. Sir, please. Yes, sir. That's all about. I want to say you, and of course, we will meet here. I will be here most possibly. I will meet with you and contact with you. That is no problem as such. And lastly, sir, that's take care of yourself and
Yeah, please, you do take care. Yeah,
your
it's
family.
likewise. Yeah. Thanks a lot. Thank you very much for your kind words.
Thank you, sir.
Yeah, thank you.